Good afternoon, Your Honor. Bryn Kurt on behalf of the people, P84009. Good afternoon.
Good afternoon. James Parker on behalf of Mr. Schuster.
Good afternoon. Good afternoon, Mr. Schuster.
Good afternoon, ma'am.
Mr. Schuster, I brought you back today for resentencing because I realized that everyone can be seated, thank you. I realized that I neglected to include a very important provision, which is tethered. And as I was thinking about this case, I wanted to be assured as well that the victim receives all of her personal property. I think you can appreciate that some of the things that she described are really priceless, and I want you to return them to her or assist in returning them to her. So I'm going to include that in your order. And I've also decided, given that you already served 6 months on this offense in pre-adjudication detention, and that my objective for you is rehabilitation, I am going to release you on house arrest with a GPS tether for 6 months. Again, taking into consideration that you've already served 6 months in jail. However, Mr. Schusterick, if you violate the
Buckle up, guys. Today we are going to watch how a routine courtroom return suddenly reshapes a defendant's future. The judge calmly explains that a critical sentencing element was missed and moves to correct it, shifting the focus toward rehabilitation instead of punishment. House arrest with a GPS tether replaces more jail time, but the tone sharpens when the judge warns that any violation of the no-contact order will trigger serious consequences. The relief comes with a clear line drawn in the sand.
The no contact provision in any way, you're going to spend at least a year in the Michigan Department of Corrections.
Can I ask a question?
You can
How do I
ask
go
Mr. Parker.
about getting her?
You can ask Mr. Parker.
What do you need, sir?
her photos? The only reason why I hung on them for long.
Mr. Schuster,
Your Honor,
Just tell me.
if the people may, is there going to be a replacement for the DVT program? Because that was the entire purpose of
yes,
the
I'm sorry.
incarceration.
Yes, it's batterers counseling.
Okay.
And thank you for raising that because I don't have that here.
And I did have an opportunity to speak with the complainant who is here. And she indicated to me that the items she is most specifically concerned about are her medical records, the entirety of her medical records.
You mean since she was an adult?
I believe her entire life medical records, Your Honor. I believe that the defendant's mother has possession of them, and I have that belief. I don't recall, I'd have to double check, but I do know that that his mother has used information from those medical records in the past to demean the complaining witness. And then the photo albums, which do contain photographs of her, as well as her sister, who I don't believe is with us anymore, Your Honor, from their childhood, from Russia, and all the way through, Your Honor. I have been informed that none of these photographs are of an intimate nature. So I did ask
From
that
here, the discussion turns deeply personal as the court addresses property belonging to the victim. Medical records spanning her entire life and irreplaceable childhood photo albums become the center of attention. The prosecutor explains why these items matter and how they were allegedly used in the past. To avoid any contact, the judge supports a controlled transfer through the police department, underscoring how even logistics in this case are loaded with sensitivity and risk.
I did ask that question. I also did float several ideas of how to effectuate the transfer of this property. My suggestion, personally, would be that either Mr. Schustrick or a representative of Mr. Schustrick takes those items to the Allen Park Police Department, leaves them there, and then either Miss Schumann or a representative of her goes to the Allen Park Police Department and retrieves them. That way there is no communication, no interaction between any parties. I think that given the extensiveness to which parents have been involved in the case, I think that would be the best bet rather than having a third party meetup not at a police station. And then on and after the date of sentencing, Mr. Schustrick's mother did reach out and text the complaining witness multiple times. I don't believe, based on the contents of those text messages, that Mr. Schustrick directed her to do that. But I just want that on the record, that contact was made. It was harassing contact by Mr. Schustrick's mother. Again, I can't establish that he directed her to do that or she did that on his direction or at his suggestion or anything like that. I know Your Honor was very adamant last time and spoke with her as well that contacting would not be helpful. And I would just like on the record that did occur and that those messages did come from his mother. I don't have anything to suggest that Mr. Schustrick was involved with that. I just wanted it noted for the record.
Thank you. Mr. Parker?
Well, can we, certainly we appreciate the court's resentencing. Can we have a list of things that Mr. Schustrick is to turn over?
The medical records and any photograph or photograph albums of Miss Schumann, and Miss Schumann informed me that Mr. Schustrick would know exactly what she was referring to.
You
As
do
far
know
as
exactly what she's
That's where the
I know what
gray
you want.
area is.
I know what you're going.
You know exactly what she's
Exactly. I'm just, I don't, medical records. Look, my mom says a lot of things.
Mr.
My mom
Schuster?
is nuts.
Mr. Schuster.
Just ask questions.
Absolutely. Look,
Just answer the
yes,
question.
oh, okay.
Just answer the question.
Mr. Schuster, how many times do you think you've been before me by now? Maybe 10?
12 at least.
Yeah. And every single time, I have to ask you to stop talking.
Sorry.
But you don't think that you need any mental health treatment.
Not true.
Ms. Kurt, I appreciate that you're giving Mr. Schustrick the benefit of the doubt concerning his mother. And assuming, especially because it was the day of sentencing, and probably that he would have had a limited opportunity to contact
This segment escalates the tension when the prosecutor places troubling information on the record. Despite court orders, the defendant's mother allegedly contacted the victim multiple times. The judge grows visibly firm, reminding the defendant that family interference is not an excuse. Interruptions are shut down, and responsibility is made clear. The warning lands hard. Continued contact could expose his mother to serious legal trouble, adding a new layer of pressure to an already fragile situation.
opportunity to contact his mother. I tend to agree with you. However, I did tell your mother, Mr. Schustrick, at length on the record, and frankly off the record. She remained for a while after you were taken into the back, that she was not to contact Ms. Schumann in any way. You need to get her under control.
You tried. I've been trying. I'm the kid. I'm not an adult in her eyes. Blah 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 blah. I've tried. I've asked her, and I haven't had contact since the day I've been detained.
Well,
With
tell your
anybody,
mother
so.
that if she continues to contact Ms. Schumann is going to have a basis for PPO. She may even have a basis for something else.
Maybe contempt her. Put her in contempt. Maybe
So-
Sorry,
You tell her.
Your call.
I'm not in disagreement.
In the final moments, the judge locks everything into place. Specific items are ordered to be delivered to the police by a strict deadline, with instructions designed to prevent excuses or confusion later. The judge reminds the defendant of his own words about caring for the victim and demands follow-through, not talk. With no further arguments, the court brings the matter to a close.
All right, so we have medical records, photo albums, and I'll order that these items be delivered to the Allen Park Police Department no later than next Monday. So you'll need to arrange that, Mr. Schuster.
And I'll make sure to put a call out to the Allen Park Police Department so that they're aware.
Thank you. And when they are delivered, Mr. Schusterick, whoever delivers them, make sure, this is really critical, make sure that that person gets the name of whomever these items are left with. Because I don't want to hear, well, I never received them. I went to the police department and nobody could tell me who had them. And you talked so glowingly about Miss Schumann, how much you care about her, what a great mother she is. You need to do this. Is there anything else?
Nothing further from the people, Your Honor. Thank you.
I have nothing at this time, Your Honor.
Judge, he'll need to contact DOC to that place.
Okay, thank you.
Okay, hold on.
I'm sorry.
No, it's okay. I'm not worried right now. Let me just say this. I won't worry at this moment about November, but you put in your motion that you were going to get October paid, right?
Yes.
Okay.
Your Honor.
Hello, what's your name?
Leanna Jones.
Okay, you need to take your hands out of your pockets if you would. Thank you. All right, is this your motion to set aside?
Yes.
All right, what's your basis on setting that aside?
I'm sorry.
Pardon?
I didn't hear you.
What's the basis of what you want the judgment set aside?
Oh, because I had missed the first court date because the lady, I had made a payment for September and she told me don't come to the court date if I had made.
She who told you
The
that?
lady in the office at Arbor One Apartments.
Okay, let me ask this. What's her current balance?
Current balance, $2,464.94. Your Honor, the motion states that she's going to pay her balance by October 31st, which she has not done.
No, I wasn't able to. My car had broke down again, but I can make a payment of $900 that's on the judgment on Monday. That's most. of the
Okay, so,
judgment.
here's the problem. The problem is that the judgment was from October. You don't have October paid, and now I've got November.
Yes, and I have started an application with I don't know what the program is called, it's for them to help me pay my rent.
Hawk?
Yes.
You got an application with Hawk?
Well, I got an appointment on Monday.
Young lady, did you have an appointment with Hawk or no?
I have an appointment on Monday. I had talked to them already, but then I had to get it.
You have an appointment this Monday?
Yes.
Do you mind if I get a confirmation of that? Amy, do you know?
She has an appointment coming up on the 18th.
You don't have an appointment till the 18th.
That's not it.
Well, that's not this Monday, but it's next Monday. But in the interim, how much has she paid since October 11th, Ms. Luckoff?
Give me 1 second, Your Honor. The last payment made was October 1st. Nothing has been paid since October 1st.
I
I
asked
don't
for
believe there's a basis to set aside the judgment at this point.
The
She
judge
doesn't-
tries to understand why this tenant missed her first court date, and the explanation only creates more confusion. As the balance is read out and it's revealed that no payment has been made since October 1st, you can feel the judge's patience thinning. This is the setup where the excuses begin, but credibility is already slipping.
Judgment at this point, she's not presented a meritorious defense. If we give her the credit for what she's saying, why she didn't come to court the first time.
Right, but I was a bit confused because she said she paid 800.
No, I paid, because the first time this was ever brought out was from September, and I paid September's rent, and she told me do not come to the court date because I made a payment. Then it dragged over into October.
Your Honor, they never.
The first hearing date was October 11th.
Yes, but that was for September's rent.
No, it includes October rent at that point.
Okay.
I know that what the complaint may have said, but your October rent would come due. That's why there was $1,194.
Right. I can making a payment of $900 on Monday for the job.
Okay, so young lady, here's my problem. My problem is why don't you at least have the $1,194, which would be your October rent?
Because I had lost my job, my car broke down, I had to use some of my rent money to get my car fixed. I wasn't able to pay.
No, I hear you, but you see the problem? Because now I'm sitting here at a hearing in November, November's rent is due.
You're right.
That's what the problem is. And then even if I take the benefit of the doubt of what you tell me you can do, right? It doesn't even pay through October. And then I've got November.
Right.
Okay, look. What can you come up with between now and the 15th? You said you had 900.
Yes. That's for October, and I was expecting the people
Hold on.
to help me with November's rent.
Okay, hold on.
I'm sorry.
No, it's okay. I'm not worried right now. Let me just say this. I won't worry at this moment about November, but you put in your motion that you were going to get October paid, right?
Yes.
Okay. You got 900 right now, right?
Yes.
Okay. Is her rent about 1,200? Let's look up.
Yes.
Is that about right?
Let me check.
Because I had 1194 on the judgment, and then it sounded like
For rent, I mean, the
1,200.
base, I'm sorry.
Go ahead.
It's 1065 for the base, and there's water, trash, gas. So it's 11, yeah, it's about 1140.
Okay, so about 1,200, whatever.
Yeah.
Okay, but you got 1194 because you got court costs in there, you got all that kind of stuff in there.
Correct.
All right, look, young lady, you got a meeting with Hawk on the 18th, right?
Yes.
There's some funding coming in that may be able to cover you for November, even if it went into December. So just listen. But what has to be paid is this judgment has to be paid.
So if I pay the judgment on Monday,
Well, how much can you pay on Monday?
well, I'm gonna have guaranteed 900 on Monday, but I can ask to borrow the $200 I'm owed
Well, you need $1,200.
for the judgment.
Well, I need $1,200 by Monday.
Okay.
Can you get that paid?
Yes, I can. Yes,
Can you?
I can try. Yes, I can ask to borrow on Monday.
Oh,
I mean, I can
look.
ask to borrow for Monday. I know I could come up with 1,000, but I'm not sure. I'm not sure about the other 200.
Here's what I'm going to tell you. This is the only way we're going to salvage it. And I shouldn't give you this, and I'm doing this over the objection of plaintiff. Okay? Because it seems to me you found yourself in a spot you don't even know what to do to get yourself out right now. Right?
Yes.
So I'm going to give you a chance to try to get it done.
Okay.
And over the objection of plaintiff, I'm going to adjourn you out 1 week on your motion. To the 15th at 12 p.m. You need to pay the $1,200. I'll make it by the 13th, which is because Monday's a holiday, and I'll give you a day. So that's that Wednesday. If it gets paid to them on the 14th, I'm not talking about it anymore.
Okay.
You need to get it there by the 13th. All right? Then you got an appointment at least coming up on the 18th with Hawk. And let's see then if we can get your November paid and salvage your tenancy. You follow me?
Yes. Thank you.
And so I'll adjourn the motion out to that date at that time. Get that paid, young lady. If it's not paid, I'm not going to be listening to anything.
Okay, thank you.
All right, guys, now we reach the turning point of this case. The judge does something unexpected, stepping in over the landlord's objection and offering one last chance. The terms are crystal clear. Come up with the full amount by a strict deadline or the court will hear nothing more. It's mercy mixed with a warning, and the outcome now rests entirely on follow-through. If you found this breakdown helpful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.